Welcome to this episode of Inside Legal ESG. My name is Pam Cohn, and I'm delighted to serve as host for this podcast production. Today, we are so honored to have with us Jacquelyn MacLennan, an EU lawyer working in Brussels with a storied history and career at White & Case, and she's an honorary professor at University of Edinburgh Law School. Welcome. I'm so glad you could join us today, Jackie.
Thank you very much, Pam. It's really a pleasure to be with you.
So let's start at the very beginning. How did you get into ESG? Tell us about your career path.
Okay, well, I was reflecting on this, as you would expect, and I thought the first thing to say is that what took me to ESG is basically what I've been watching happen around me. I think that all of us cannot have escaped the implications of climate change and what we see around us in terms of weather patterns. Maybe this has been more influential on me than some because I grew up in the Highlands of Scotland, surrounded by mountains, by lochs, by the sea. I was surrounded also by people whose livelihood depended on the sea and the land. So I think I've always felt that environmental issues are key. And maybe without being aware of it, that took me into an interest into environmental law. I was also brought up in a family which was very grounded generationally in its place. And I benefited from state school education, which was really high quality. And so I grew up in a values-driven environment, I would say, with a belief that everyone had a right to fair and equal treatment and access to justice was fundamental. And I think that's underpinned my belief in the importance of ESG in the widest sense. And then I think another influence on me has been the journey that I've had since law school. And I owe a huge debt of gratitude to Edinburgh Law School, where I chose to go, because they gave me the fundamentals, the basis on which my career has developed. That's partly the subjects that I was exposed to at law school, a fantastic variety, including EU law and international environmental law, which is basically what I founded my specialist areas upon. But I think more than that, the professors and the courses that I did at law school made me look at how the law is, what it should be, and how it should be used for the benefit of society. And I did one particular course which was called the legal process, and it asked and made me ask of myself fundamental questions about what is the role of the legal process, who's it there for, and what is the role of lawyers, and what should they be doing to use the law for the community, the environment, society at large. And I think that has also factored into why I think ESG is very important. I think possibly it is that streak of idealism that many lawyers share, which makes them believe that the fundamentals of ESG are something which should not be overlooked. So when I went into practice, and that's a long story in itself, I did believe that I had a responsibility as a lawyer to question what I saw around me. And I think from my upbringing, I also believed that I had agency to make change where I saw change needed. So that's the second element of what fostered an interest in ESG. But what really has taken me to ESG is, I think, and this is very grounded in my career, particularly at White & Case, what took me to ESG was client demand. And so I have spent many years as a partner with White & Case. I developed a practice which is fundamentally EU law. I started with the legal service of the European Commission, and that's what took me to Brussels. But I moved into a boutique practice, became a partner there, and then joined White and Case. And my practice was founded in EU law, particularly complex antitrust cases, complex trade cases, and I litigated in the EU Court of Justice in Luxembourg and domestic courts as well. But I also handled, as I mentioned, because I had an interest in it, environmental regulatory cases. So I, as my practice grew, was advising governments, I was advising general counsels of some of the biggest multinational companies. And when people asked me what I thought they should be thinking about, I would always talk about antitrust risk. If you can be fined 10% of your worldwide turnover, that's something you want to know about. But I would also talk about wider issues, about responsible business issues, because I felt that they were really key. And then, I don't know, early 2010 onwards, I realized that when I asked general counsels or C-suite people, because I was also involved in board discussions, what was keeping them awake at night, I wasn't hearing antitrust risk. It wasn't that had gone away, for sure it had not. But in Donald Rumsfeld's terms, I guess it was a known unknown. And what was keeping people awake were the unknown unknowns. And that was this question of what might be happening in our operations outside head office that could be a problem for us in reputational terms. What might be happening in our supply chains, which could be rather uncomfortable if there were children involved or forced labor involved. What's happening to the waste coming from our plants or our emissions, and what's happening in the wider supply chain. Is that a problem for us reputationally? But more particularly, people were beginning to ask, you do human rights work, and I did because of my pro bono practice. And they said, well, and you also do some environmental regulatory work, and I did, both on a pro bono side and as part of my practice. And they said, do you feel that there's actually a legal liability risk? And my answer was yes. Watch what's happening in this space. And that was what people were really being interested in. And the conversations that I had were showing me that there was this area of concern that needed to be addressed. Now, I was in a very fortunate position as these years went on, because in White and Case, I had a number of roles. I was always, throughout my career, fundamentally a litigator in EU law, but I also, in White and Case, which is an international firm, I had a number of roles with the global firm, which included a number of years on the firm's executive committee. And that was basically three of us, plus the firm chair, who were responsible for running the firm. And my mandate was client relationships. And I also covered Asia particularly, but global client relationships. And that role enabled me to get to know the partnership of White and Case, the firm in its widest sense. But it also gave me contacts with clients that I would never normally have had. And it also enabled me to make change within the firm in a way that would not have been possible if I was sitting purely as a partner in the Brussels office. And as I say, my conversations with clients were not just the clients that I specifically dealt with in my role as their antitrust counsel or their trade law counsel. I was also, in my role on the executive committee, engaging in a review of our client strategy and talking to general counsels in companies and financial institutions all over the world in all different sectors but I was hearing these issues, which are, what about human rights? What about environmental risk? What about these things that we haven't previously been concerned with so much that I thought, okay, we have to make a change within the firm. And working with other very committed people, we set up a business and human rights group that was informal until I think first meeting was 2016, something like that. But then it became a formal interest group of the firm from 2018 onwards. And that led to me being involved in setting up the firm's ESG and sustainability group. And I was on the core group, in the core group of both of these groups of the firm. And that, you know, that took me to the heart of ESG. And one of the things that we did, which I think flows from my view that it's really important for all lawyers these days to understand ESG issues. What we did in, I think it was about 2015, 2016, we started to do it, and then we rolled it out maybe 2016, 2017. We organized a course for all White and Case lawyers, and it was tailored geographically and to practice areas, but it was basically to explain to our lawyers the developing framework in what we now would term ESG, but what we were looking at there particularly was environmental risk and human rights risk, so the S and the E and the S. And particularly we were explaining that there was this area which was soft law, the UN Guiding Principles on Business and Human Rights, which was requiring due diligence as a process into the risk areas of human rights and environment. And we were explaining that the soft law area, and that also included, there was the Equator Principles and the principles for responsible investment. These were becoming hard law, and there was this change in the legal environment, and our lawyers, we believed, needed to understand that. And so this training program was pretty unusual. In fact, we got an award from the Financial Times as innovators in the Innovative Lawyers section. But it was something which was very, very valuable, A, for our lawyers, but B, because when we talked to clients about it, they said, well, actually, can you come and talk to us too? And so we were able to implement something quite structured there. I think that the question of, you know, what took me to ESG, which might be of relevance to others, is that it was fundamentally important to our clients. And as a result of that, we reacted fairly quickly. But I think all lawyers now really must understand that these issues are not to be ignored. And I think that there's many, many ways in which that's communicated more widely. I think I just came to it a little bit earlier. And I feel very proud, in a sense, of the legacy that there is in White and Case, at least, as a result of that realization. And I know that you've talked to I think Taylor Pullins early on in this podcast series, who's you know, a great lawyer and a really a lovely person, about what White and Case is doing.
So one of the things you mentioned in that process of you getting to where you are today is this fundamental role of lawyers. And that is a topic that we discuss at almost all of our legal ESG events. What is the appropriate role of lawyer? I would love to get your thoughts on that.
Yeah, I do have quite strong views as to what the appropriate role for lawyers ought to be. I guess I would answer that question in one sense by saying, I think lawyers have a responsibility to ask themselves the question, am I doing the right work in the right way for the right client? And I think that this is important in the training of lawyers, and I think this is important to remind lawyers as they go through their career. And I think that lawyers ought to every so often be exposed to that film about the Panama Papers, you know, the one with Antonio Banderas, just to say, hold on a minute, stop and think. And I think that the role of lawyers probably in this area has been very well spelled out in the IBA's guidelines on business and human rights for lawyers. And a lot of bars are now saying very clearly to their lawyers, you've got to tool up in the area of ESG. You've got to understand the risks that your clients are exposed to and make sure that you know the law. And I think also lawyers are being required by their bars to approach their representation of clients in a slightly more reflective way. And the bars and the IBA are saying lawyers have a duty when they are giving advice to their clients to make sure that they point out to clients if they see reputational risks or if they see law developing in a way which is important for a client, but which maybe the client hasn't really thought about and the client isn't taking account of in what they're doing. And so I think that the role of the lawyer these days, and there's, you know, much academic literature on this, the role of the lawyer is, of course, you know, to represent your client in the best way that you possibly can. But it is also to take account of the wider requirements of your duties to the court, your duties to the legal system, and your duties to society at large. And that means that your advice may not always be comfortable for clients, but that's what you ought to be doing. You're on mute.
Thank you. You and I certainly agree on that point. I want to get to an article that just recently came out in Forward Law Review, an article that you wrote called ESG and Pro Bono, Parts of the Same Puzzle. Now, you hinted at this a little bit in your introductory remarks and what you worked on in your pro bono time, but tell me what you think the linkage is and how they work together.
Okay. No, I'm very happy to. I think that the article came about as a result of me thinking a great deal about the lawyer's role when we talk about ESG, and that evolved as I was working through White & Case. It also came out of the fact that one of my roles in White & Case, and one of the very important roles that I had, was to be the head of the global pro bono practice of White & Case for many years and until I retired. And my role there brought me into contact with how a number of different firms organize ESG, and the role that I currently have with I would say PILNET, which is the Public Interest Lawyers Network. I'm on the board of PILNET, and PILNET has a very well-known global forum every year, which brings together lawyers from NGOs in many, many, many different sectors from many parts of the world. PILNET is truly global. And the global conference brings in also private practice lawyers offering pro bono services. And within the context of PILNET, there's been quite a lot of discussion on how ESG and pro bono fit together. And I've talked at a couple of keynote sessions on that. So my thoughts had evolved, and I also talked at the IBA actually when the last global gathering. I was asked also to talk there about this question about the interaction of ESG strategy and pro bono strategy. And my view is that law firms, and I think this is something which you would agree with, must have a very clear and a very personal ESG strategy these days, that's fundamental. And I believe that that is something which should be very beneficial for pro bono work, because I see the need for pro bono increasing, and I mean by pro bono work by law firms and lawyers, no matter where they're involved in practice. I see that growing because the governments are never going to fund access to lawyers in the way that they potentially should, and so lawyers have to be there to offer that. So there is an absolute need for pro bono work, and I think that an ESG strategy that a firm adopts, and an ESG strategy which a firm is asked about by its clients, which is increasingly the case, that should include reporting on the pro bono offerings of a firm. But I do think that if a firm looks at pro bono as only being ESG, there's a risk that some elements of pro bono work are compromised. And I have seen some areas where this has been a risk, not in point in case, I may say immediately, but I do think that pro bono work is key in many different ways. And one of the particularly important ways is in cases which involve individuals being assisted in, their legal problems. And that could be a legal problem with, do I have a right to get some housing assistance here? Or it could be, I've been found guilty of a murder, I've been sentenced, this is totally a wrong, or B, the sentence is fundamentally disproportionate, I need help there. These are two very different types of cases, but they're access to justice cases. And if a firm sees pro bono work as, part of its ESG practice, and its ESG practice is also giving advice on ESG areas to clients, the risk for me is that the pro bono work that the firm does is really seen as, well, let's see how this will factor into our ESG work. And it could be that it's really good pro bono work, but it's for international organizations or national organizations who are, involved in protecting the environment, or they may be involved in, some element of giving assistance to migrants, but in a wider sense, and they're not focused on individuals' access to justice problems. And that is where I think firms need to look carefully at ensuring that their lawyers are incentivized to continue to do pro bono, but B, to continue to do pro bono, or to start doing pro bono in areas which are both to do with ESG subjects, but also are in these areas which have nothing really to do with particular ESG subject area, but are so fundamentally in need of legal assistance. And these are the access to justice cases.
Yep, I completely agree. So we're at the beginning of 2025. What do you foresee as being in store for the ESG world, the legal world, both in the EU and other parts of the world?
Yeah, well, I guess we're recording this podcast 2 days after the inauguration of Mr. Trump, President Trump.
Right.
So it's not to be ignored. And I don't think any of us in the legal world could have escaped it. And so what does that mean? Well, it means, I think, that the ESG backlash, which has been talked about a lot, is absolutely a reality. We can see in the inauguration speech and in the signing of the executive orders over the last days that in the US, there's been a dismissal of human rights. The approach on DEI has got to change, and LGBTQI plus rights, women's rights, the advancement of minorities. That's really there's a total change of approach there, and that has got to be addressed in the US. I think also we see in the last days this dismissal by President Trump of climate change. The US has been taken out of the Paris Agreement the second time. And in the inauguration speech, there was reference again to this mantra, drill, baby, drill, which will change completely, I think, in the US, the approach to fossil fuel extraction industry. We've also seen, I think, in a kind of unsavory way, what some media have described as, the corporate leaders or the Silicon Valley tycoons, bending the knee to Trump. So that's a reality that we have to accept. Not just in the last 2 days, but the beginning of this year, we've seen banks and we've seen pension funds come out of collective actions intended to increase voluntary disclosures in the sustainability area. So the Net Zero Banking Alliance and the Net Zero Asset Manager group have seen the exit of US banks and pension funds, as I say. And I think, you don't have Mark Carney there focused on trying to argue the benefits of these alliances in the way that he once did, because he's more interested in other things right now. But there is this change fundamentally in the US, and it's not just in the US. Because in the EU, you've got, well, the EU, first of all, has been the acknowledged leader in pushing the corporate sustainability agenda. But now there's a very clear retraction from that. And this is partly because the bloc over the last year has changed in political character. So the rise of the far right is very noteworthy. We've got new leaders, Austria most recently, but Italy, change and lack of leadership in France and Germany at the moment, but the rise of the far right there is very, very noticeable. But also in smaller countries, Belgium, the Netherlands, Denmark, Sweden. So and that's not even touching on what's happening in Hungary. But Hungary, Slovakia, it's so there is this real change in the political character of the EU. And if you couple that with the economic difficulties and the lack of growth in the bloc, you just see that there's a huge pressure for the EU to move back from its green and its sustainability agenda. And the rise of industry and saying we cannot handle more costly regulation is very apparent. And in fact, I signed, I had input into the drafting and signed a letter just the other day, which is from I would say, the business and human rights community,
Mhm.
addressed to Commission President saying that the new Commission initiative, which is to look again at the reporting requirements that have been introduced in the the legislation on CSRD, CS triple D, that's the Corporate Sustainability Reporting Directive and the Corporate Sustainability Due Diligence Directive, and the EU taxonomy, that those should be looked again to make them more coherent, and to make it easier for business to comply. But the problem is that that could be a way of opening everything up to new negotiation, and that would not be a good thing. And so that initiative by the Commission is something that we as lawyers and others are saying is potentially very dangerous, and there should be a limitation to what the Commission does, which would be make it more coherent where there is any incoherence in reporting, but don't, for goodness sake, change everything. And I think it's important to note that a number of companies have also said the same thing. But what we can see is that there is, there's backsliding by the EU. There's not going to be the same push forward.
Right.
So what does that mean for 2025? Well, I think there's going to be a real difference in communication. I think for a start, we won't be talking about ESG in the terms ESG. I think we'll be talking about sustainability. I hope we're not talking about responsible business or something like that, because I really feel very strongly that we're beyond the realms of what's kind of voluntary, nice to have action by nice business. I think we're in an area where we need mandatory regulation, mandatory law. But as I say, ESG is now too loaded. And so I think we have to find another word. And maybe that is sustainability. I think we'll see the same in DEI. You can't use these terms anymore, but I think we'll look and we'll be talking about inclusion. So I think we will see this difference in communication as well in terms of how some of the big companies are talking about what they're doing. And I think we'll see, as I say, a slowdown in the amount of new regulation being adopted, although I think that will actually be different in the UK, because I hope that in the UK there will be a tightening up of the legislation on modern slavery, and I hope that there will be a legal measure on corporate sustainability due diligence like the EU. And I hope in the UK there will be a law adopted which will restrict the sales of products in the UK which involve forced labour, like the EU has adopted. So there will be still new law in some places, but I think generally speaking, globally, there'll be a slowdown. But fundamentally important, I don't think ESG is going to go away. Just because Donald Trump says climate change doesn't exist, that doesn't mean that everybody accepts that climate change doesn't exist, and it certainly does not negate the photographs that we had of LA over the last weeks and the terrible, terrible fires which accompanied last year's terrible, terrible floods. So
Exactly.
I think that companies, they are going to have to deal with the realities of what's happening in the environment, the realities of the human rights situations in their own businesses, and they are going to have to deal with these for their own financial long-term interests.
Yes, their long-term viability, right?
Exactly,
I always like
exactly.
I always like to use the word sustainability along with viability, because too many people think sustainability just means the climate. But
Mhm.
really, what we're talking about with ESG is all the things you have to take into consideration to make sure your company is viable long term.
I agree.
I also heard somebody say recently, the climate doesn't care whether you believe in climate change or not. So it doesn't matter whether you believe. So here's the final question. Given everything you just described, which frankly can be a little bit depressing, what gives you hope in spite of all of this? What gives you hope?
Yeah, I mean that's a great question because we didn't even cover, what are we going to see? We're going to see more litigation, we're going to see more greenwashing cases, we're going to see,
Yes.
a lot of things that companies have to be very aware of, more directors fiduciary duty cases, all of these things. Um, does that give me does that give me hope? Well, actually it kind of does because what gives me hope is the the changes in the current legal environment. I do think that you do need law and you do need absolute prerogative to comply with the law for companies in the broader sense to make change. And so I think having the legal environment that exists, that means that it's not just an EU company that has to think about this. It's a company anywhere. If you want to do business in the EU, if you want to be listed or if you want to make sales, you are going to have to be compliant with these EU laws in different ways. So this is very far-reaching. So now what gives me hope is we have the structure in place, which I think will really be a sea change globally. Of course, we need to have enforcement, and we need to continue to evolve here. But there's a new legal system there which can be copied in some jurisdictions, and which I think will alter how many companies do business, and that I think is for the good. I think also when I think about what gives me hope, I would say it's many of the people out there who are really working to try to make the future better in whatever way they can. And that I see and I value very highly my work with Edinburgh Law School because I meet students, I meet postgrads, I meet teachers there, and I see what the concerns are that people have for the future and what they're trying to do to make it better. And that I think is definitely something which makes me optimistic. I'm also quite hopeful about the change that might come about with law firms having an increased focus on ESG and really trying in a strategic sense to think about what ESG means for them, both in terms of how do they advise their clients, and that's, as I say, as we've discussed in this conversation, that is something which bars are addressing themselves too. But I think internally within law firms, there will be a number of changes which I think will be for the better. And that will be an increased focus on what kind of clients firms work for, a kind of framing of what firms do in a way which is more coherent and which requires better oversight of what individual partners are actually doing, what clients they're taking on, what work they're taking on for clients that the firm has. And I think that's positive. But I also think that the focus that law firms have on developing an ESG strategy, if that means that they improve their own efforts in terms of their use of energy and their emissions, that is all to the good. But fundamentally for me, because I do believe that it's important for society at large that law firms and lawyers make a serious and high quality pro bono commitment. If an ESG strategy is going to give some oomph to the need for lawyers to do more pro bono, then that's a good thing.
Good thing.
So those are areas where I do feel a bit of hope. I think I was teaching just the other day and we were discussing with the students John Ruggies' idea of principled pragmatism. And I was saying, well, that's kind of, how I feel. I think it's better to harness efforts to make some change in the right direction than to do nothing. And I see many people doing that, and I see laws adopted which are doing that. I think there's much more to be done, but I think we have been moving in the right direction. I think, as we've discussed, there are definite obstacles in the progression that we want to see, but I do think that society requires us to focus on these issues that, we describe as ESG, and we're doing that.
And I think to your point earlier, you used the word agency. Lawyers have agency to affect change in almost everything they do. They're in the boardroom when every decision is being made. They're advising clients on the risks of decision making. They have the agency. We just have to have the urgency to affect change. Thank you so much for your time today, Jackie. This has been a wonderful conversation, and I'm sure our listeners have learned a lot. Thank you so much.
Thank you, Pam. It's really been a pleasure to talk to you.